Everybody, and a very warm welcome to this, which is our vlog on getting ready for the Procurement Act 2023. And I'm here today with many of my procurement colleagues, Claire Crawford, who is a partner and procurement litigation specialist, Shailee Howard, who many of you will know, who leads our procurement team, Victoria Armitage, who's a senior associate, and we all work together on everything to do with procurement. And so I think what we thought we would do today is just spend a bit of time touching on some of the key areas of change. And probably the first thing to start with is a little bit about the aims and the implementation of the Procurement Act. So we may have had Royal Assent, but that doesn't mean that the Act is already in force. And I think many of us will heave a sigh of relief to know that. So in terms of the implementation of the bill, we're looking to for the bill to be implemented or to come into force in autumn 2024. So that is at least a year from now. And what's happening before then? And I think what we're going to see is quite a lot of initiatives by the government in terms of knowledge drops, self-guided e-learning products, communities of practice, all sorts of resources to help us all get ready for implementation of the Act. And hopefully the Cabinet Office has committed to a 6-month notice period before implementation. So hopefully we will have all the secondary legislation, all the knowledge products, and then we will have 6 months to get our heads around the new regime and what it might mean for us internally. So looking at the coverage of the Act, I think, Victoria, you were going to say a few words on that.
Yes, thank you, Jenny. I think it's important in understanding the coverage of the new procurement regime to understand the structure of the regime to begin with. The bill itself is the base layer of the procurement reform that's coming our way, and that is supported by regulations which contains a lot of the detail that is not set out in the content of the bill. There are 2 consultations that have recently just closed and are now back with Cabinet Office for finalising the content of that, which contain a lot of that detail. That's the Procurement Act 2023 Miscellaneous Provisions Regulations 24, which has various calculations. It's very much the miscellaneous bits of the bill and of the procurement regime as we currently understand it being set out in more clear detail as to how that will work for the future rules. And secondly, the real meat of what I think everybody's really looking for is the procurement transparency regulations, the what is it exactly that we need to do, what is it that we actually need to publish, how does it work on the ground and in practice. So you have the bill supported by the regulations, which sets out the entirety of the rules and the regime. The bill itself is structured in a way that tells the story of a procurement, and I think this is quite important too, because the procurement regime, the coverage, is going to be broader than we currently understand it. So when you are looking at the bill, you will see that it tells the story of a procurement. You've got the scene setting in terms of your key definitions. You've got running a procurement, which Shailee's going to touch on in terms of how you go about that. A lot of that hasn't changed in substance. A lot of what you expect of the procurement regime does continue through into the bill. What we might be less familiar with is the scope of procurement being wider than we currently understand it, and that brings in the living with the contract. It's the contract management piece that is brought into scope of the new procurement regime, which we won't be quite as familiar with. And there will be an awful lot of the detail of how that operates that is coming through in regulations. And you will see on our website there will be more information coming on that in the form of future sessions. Finally, you've got the content of the schedules will have an awful lot of detail set out in those as well. So when you are looking at the bill, you will see you have fairly skeletal early sections and early parts, and then the detail of, for example, all of the exemptions are set out in Schedule 2. you've got direct award justifications set out in another schedule, and that will really help you navigate and signpost you through the regime and through the bill.
Thanks for that, Vic. Shailee, would you say something to us about procedures, frameworks, and dynamic markets? Because I think this is an area where we're really going to see an awful lot of change.
Yes. Hello, everyone. So I'm going to talk a little bit about the procedures under the new Act, what framework agreements might look like, and the rebranded dynamic markets. So starting with the procedures, you'll all be familiar with the current procedures under the regulations. You have the open procedure, the restricted procedure, competitive dialogue, competitive procedure with negotiation, innovation partnerships, and direct award. What the Act does is effectively simplify the procedures. So you have the open procedure, which looks very similar to how it does now. And then you have something called the competitive flexible procedure. And this is the new flexibility under the Act. This is probably one of the more significant changes because it will allow greater flexibility to design more bespoke procedures, and the authorities have the ability to flex their procedure as long as it's proportionate to the contract. So that might include a multi-stage process. It's likely to still include a selection procedure, but there's a bit more flexibility there to really think about what it is that you're procuring and how the process might work best for you. The time limits under the Act are largely unchanged, and I think this is an area where we will expect to see some templates and case studies and some further guidance to make sure that authorities are really benefiting from the flexibility that this new regime affords. Another key point to think about is links to sort of pre-market engagement. That's another area where the Act does encourage pre-market engagement, and that will help to streamline the procurement process. Thinking a little bit about direct awards, all the grounds are set out in Schedule 5. These are largely the same. There are a handful of new ones. For example, prototypes and developments are called out as a specific ground. There is an ability to switch to a direct award. So, for example, where no suitable tenders have been received. And there are some transparency obligations around making direct awards as well. So largely the same, but there are some slight quirks and some slight differences in how you go about telling the market that you are entering into a contract without a further competition. A quick word on framework agreements. So framework agreements, there are now 3 options. So you have regular framework agreements as we have now, where the maximum term is for 4 years. You then also have the potential for a longer framework if you can justify a longer framework. And then you have this new concept of an open framework. And effectively what this means is where you have successive frameworks on substantially the same terms, and these can last for up to 8 years. So if you have a regular requirement for something and the terms don't necessarily change very often, then an open framework might be the right mechanism to use. I think this is another area where we're expected to see lots of guidance to make sure that authorities really do benefit from the flexibility that open frameworks will give. And finally, thinking about dynamic markets. So as I say, this is the rebranded dynamic purchasing systems. The dynamic markets will be available for all procurements, and authorities will have to publish something called a dynamic market notice on establishment, which will really set the rules of how the dynamic market is designed to work. It will be interesting to see whether authorities will use them more often, not just for commodity-based items, but for more complex requirements too. So what does this mean for authorities? So as I say, there's much greater procedural flexibility, but it's really important that you're thinking early about the processes and the resource that will be needed to take advantage of it. And this is an area where I think guidance and training from Cabinet Office will be invaluable to make sure that the right people within the organisation have the knowledge to implement the changes. If you're a supplier, you may well be reacting to slightly different looking procedures. So you should be expecting a slight change in perhaps dusting off those stock answers that you may have, because the process may well look different. There are also increased opportunities to join framework agreements if you have an open framework agreement, for example, and indeed dynamic markets. So some great flexibility afforded in the Act, but I think it's a case of watching this space for further detail on how authorities and suppliers might make the most of those flexibilities.
Thanks, Shailee. So lots of change procedurally. Just to touch on also exclusions and debarments, because this is where we will see something quite new under the Act, which we don't have under the current regulations. So I think we are all currently familiar with the mandatory and discretionary exclusion grounds which are set out in the CCSSQ. Broadly speaking, they are copied across into the Act, but they've been given a new name. So the mandatory exclusion grounds are now called excluded offences, or suppliers who fall foul of those are called excluded suppliers. Those were set out in Schedule 6. And suppliers who have failed a discretionary excluding ground are referred to as excludable suppliers. So we've got these new concepts of excluded and excludable suppliers. Broadly speaking, the actual exclusion grounds are similar to what we currently have in the regulations. One significant difference is the discretionary exclusion ground that we currently have around poor performance. So currently under the current regulations, that's quite a high bar, and you need effectively a court determination to terminate the contract for you to fall within that discretionary exclusion ground. That bar is going to be made quite significantly lower under the Act. So it will be an excludable offence if there is a significant breach of a contract which remains unremedied. So that could well have an impact. The other thing which is really new, and I think will be of interest and perhaps also concern to suppliers, is this new concept of a debarment list. And this is a list which is kept by the government of all suppliers where a decision has been made to debar them from being able to compete for public contracts. I think suppliers can be reassured that that there is a process to being put on this list. It's not an arbitrary decision by the government. So first of all, wherever an authority decides to exclude a supplier based on an excluded or excludable offence, it notifies the government, which then investigates and makes a decision as to whether that supplier should be put onto the debarment list and how long that debarment should be. And now, before the supplier's name goes onto the list, there is an opportunity for that supplier to effectively apply to the court for a suspension of that decision, pending the court actually being able to look at it and decide if it's fair or not. That works very similarly to how the automatic suspension regime works currently. And there are rights of appeal as well, but that is a significant change. It's not something which features in the current regulations. Just the other thing to say on this really is that it's not only the tenderer which the authority needs to assess to see if they are excluded or excludable. They also need to look at connected persons, associated persons and subcontractors. So what does all that mean? Well, a connected person is somebody who has any kind of significant influence or control over the tenderer. So, for example, a parent company, a director, anyone else who, for whatever reason, has significant control in accordance with the Companies Act definition. Associated persons are other suppliers upon whom this tenderer is relying to meet the selection criteria and to be able to meet the requirements. And then subcontractors obviously are those suppliers to whom a portion of the requirements would be subcontracted. So in relation to all of those connected persons, associated persons, subcontractors, the authority will be applying that test. Is this supplier within the excluded or excludable grounds? But the difference here, though, is that if the connected person or associated person or subcontractor is within those grounds, then the authority has to give the tenderer an opportunity to replace that person before actually excluding that supplier. So quite a bit different in relation to exclusions. I think we're going to see, as with everything to do with the Act, the authorities are going to have to really look at creating new internal processes. So how are we going to check the debarment list to see if our tenderers are on it? How are we going to check the status of connected and associated persons? I think that new possibility of excluding for unremedied poor performance will be of interest to authorities, not least because the bar is quite a bit lower than under the current regime. And I think in terms of suppliers, we want to be very careful that they understand the debarment process and all the rights within it to halt the process or to appeal so as to preserve their position to the maximum extent possible. And in relation to poor performance, if you're a supplier and you get a notice from an authority saying you must improve your performance under a contract, really important to take that seriously, because under the Act, that kind of issue could ultimately form basis for an exclusion. So quite a significant impact, I think, for authorities and suppliers alike. And now we're just going to have a quick look at transparency, which I think it's fair to say is going to be one of the biggest changes that we're going to see in the Act. And I think Victoria is going to talk to us about that. Thank you.
Yes, thanks, Jenny. I think people need to be ready and braced for the level of transparency that is going to be expected under the Act. You will be expected to publish notices for each stage of the life cycle of a procurement or a contract. It's back to that storytelling. It's telling the story of the procurement from the beginning, middle to end, right through. And by end, we're talking expiry or termination. So it's the entire life cycle of that procurement and of that contract and the procurement of that contract. There will be a great deal more transparency, and that will inevitably drive best practice by sheer force of visibility, frankly. But I think that does mean it has quite an impact for suppliers and for authorities. In the case of authorities, that expanded publication regime is going to be a significant workload. I think people, as I say, need to be aware of that and brace for that, and start looking at their internal process in terms of resource and forward planning. Pipeline notices, for example, being aware of your pipeline and then being able to work forward from that will be immensely helpful to authorities. Increasingly, it's going to be significantly less difficult to hide where, let's say, for example, contract modifications may have in the past fallen under the radar. That will be visible with contract modification notices being published for those contract modifications. From a supplier perspective, it means that the market is going to have much more access to information about the performance of your contract. Where KPIs may be published, it means you will have greater opportunity to see what is coming, what those pipeline notices say is going to be put out on the market. It also does mean too that that greater visibility of what is happening during the lifetime of the contract means there is a potential greater opportunity for litigation as you become aware of contracts being expanded or directly awarded more readily.
Thank you, Victoria. So yes, transparency is going to be a really big change, which I think we're going to see affect the procurement landscape really dramatically. I think it's fair to say that it's not a sea change in relation to remedies and oversight, but Claire is going to just talk us through about what is changing and what the impact might be on authorities and suppliers.
Thanks very much, Jenny. Hello, everyone. Yes, that's absolutely right. In relation to remedies and oversight, the broad headline on remedies, both prior to and after the contract's been entered into, is that they remain substantially the same. The process for challenging the outcome of a procurement is still through the courts, and many of those more radical changes that we saw in the Green Paper have not been taken forward in the Act. So as it stands, the approach to legal challenges remains very similar under the Act, but for a few sort of points of note in relation to our current remedies, which I will give a mention to, and looking at how those affect both authorities and suppliers. We've got sort of, in relation to the automatic suspension, there are some slight changes in relation to that, and the remedy from an authority's point of view is arguably narrowed slightly. The reason for that is the Act now suggests that the automatic suspension will only be triggered if a claim is issued and the authority is notified of the claim during the applicable standstill period. So previously we had a situation where the automatic suspension would apply at any point up to the contract being entered into. Now it simply applies if it's issued within the standstill period. So that does represent a narrowing of the existing remedy. We also have a prescribed test now in respect of the lifting of the automatic suspension. However, it is thought that that is broadly the same as the test that's been adopted and developed through case law. So we're not expecting huge amounts of changes there, other than having an express test within the Act. For authorities as well, there's potentially, the limitation period in relation to ineffectiveness claims has been widened slightly. So ineffectiveness under the Act has had a bit of a rebrand. It's now known as set aside. And the limitation period in relation to that has now been linked to the knowledge of the supplier, which does represent a slight widening of that in suppliers' favour. Also, we'll expect to see for authorities the drafting of the standstill letter, which is now under the Act called an assessment summary, is going to look quite different. The Act isn't explicit in terms of the detail that needs to go into the assessment summary. However, we can see through draft secondary legislation that we have at the moment that the language around what is or isn't to be included in that assessment summary is going to change quite significantly. For example, we no longer have reference to the concept of relative advantages and characteristics of the winning bidder. So that's something to watch as we see the development of secondary legislation come through. Looking at suppliers sort of briefly, again, it's sort of that suspension and change to the standstill period is going to be quite significant in terms of issuing a claim. And also then they can now expect those standstill letters and the information to be contained in them to look quite different. And so it will involve sort of some careful sort of perusing of the secondary legislation to see what the authorities are now obliged to do to make sure they're receiving the information they should following the outcome of the procurement. But overall, challenges still continue to be high cost and high risk for suppliers, and the limitation periods remain short. One new area that is set out under the Act is in relation to procurement oversight, and under the Procurement Oversight Unit is expected to be able to investigate procurement activities of an authority and issue recommendations and guidance if it considers that that authority is not likely to have complied with any part of the Act. So whilst that it's not expected that the Procurement Oversight Unit will have the ability to adjudicate on the lawfulness of any particular procurement, it can provide another area for suppliers to look at if they consider that they'd like to try to change the way that authorities practice their procurement practices, or the way they approach procurements, or if there's a sort of thematic issue in terms of the way that they're operating. Specific procurements, however, if a challenge needs to be brought in relation to that, that still remains a High Court process. And so at the moment, it's not clear how much power or impact the Procurement Oversight Unit will have.
Thank you, Claire. So that's on remedies and oversight. Some changes, but not a sea change. I think, as Victoria said earlier, procurement, as far as the Act is concerned, is thinking about not only the procurement of the contract, but also the management of it, right through to the termination of it. So we can see in the Act that there are quite a few interesting features around contract management. Shailee, do you want to talk us through some of those?
Yes, so there's a couple of things to talk about here. Firstly, as Victoria said, contract changes, they are currently within the scope of procurement legislation and will continue to be within the scope of the Procurement Act. A couple of things to talk about in particular. So what the Act does clarify is that where you might have a public contract that potentially was below threshold or not covered by the rules, but following the change becomes a public contract, then the rules will apply, and that's called a convertible contract. I think that's something that is broadening the scope of the modification regime. All the different grounds for modification are included in the Act, and they contain many of the same permitted modifications. They are now set out in Schedule 8. As Victoria has also said, transparency really is at the heart of the Act, and authorities will be required to publish contract change notices when they are making amendments. So again, thinking quite carefully about planning for those contract changes and making sure that your processes are in place. So the permitted modifications are all set out in Schedule 8 of the Act. They include many of the same things that we have under the current regulations. For example, where you have additional goods, services or works that have become necessary, you still see the 50% cap on value for a number of the grounds. What's also changing is that authorities will have to publish a contract change notice before making the modification. There are some conditions to that, but broadly speaking, there is that obligation to publish a notice, and there is also the opportunity to hold a voluntary standstill period as well. So that's quite different to what we have at the moment. The other key thing to think about is reporting. So under the new regime, there will be an obligation to set and publish at least 3 key performance indicators for all contracts over £5 million, and that will also be coupled with regular reporting requirements. So really shining a spotlight on performance of public contracts, and that's quite different to how contract management is run currently. There are also separate rules around poor performance, so it's worth thinking about those carefully, and we will go into more detail on each of those new features of the Act in later sessions. So what does this mean? So as I've said, the detail of all contract variations will largely be in the public domain, and that means that they are susceptible to challenge. So the more savvy bidders will likely be keeping an eye on changes made to contracts and potentially asking questions. There will also be a need to check your contracts that make sure they align with the reporting obligations that the Act expects. If you're a supplier, again, it's thinking about the spotlight that will be shone on your public contracts, so things like contract performance notices, etc. You may well be wanting to think about those KPIs in advance, potentially during the pre-market engagement phase, to make sure that they are meaningful and they are correct, because there is this obligation to publish those during contract performance.
Thank you, Shailee. So just to wrap up, so what's next? So a little bit about what we in the Mills Reeve procurement team are doing in relation to the Act. So we've got Royal Assent, but it's really just the start of the journey. It's not the end of it. So if you wanted to keep up to speed with what's happening, we will be posting all of our updates on the reform page of our procurement portal. So that's www.procurementportal.com/reform. So do keep checking there or bookmark that page if you're interested in keeping up to date. Many of you may be familiar with our 5 in 25 series, and this year we're running that on the Act itself. So we're devoting this year's series of 5 in 25 webinars to the Act and how the Act will affect each stage of the procurement. And if you look at our procurement portal, you'll be able to see how to register for that, and indeed to register for all updates in relation to procurement law and procurement law reform. The other thing you might want to bookmark is the UK Parliament page on the Act. And also the government does have a page on transforming public procurement, which is helpful to keep an eye on, because not least because that's where all the announcements about their learning tools and e-learning webinars and all that sort of thing will be posted. So thank you for listening. We hope that you found it helpful. And we're really looking forward to the next year, seeing where the Procurement Act goes and getting ready for implementation. Thank you.